Hello friends, in my YouTube channel Advocate Amit Kumar Gupta. Today I will going to discuss the case of Ashok Leyland Limited versus Commissioner of Income Tax. This case has been reported in 447 ITR at page number 661 and the date of the judgment is September 7, 2022. This case has been decided by Supreme Court and this case is regarding assessment year 1991. The case is very long in litigation and in this particular case the matter is related to section 80 HHC deduction. Although it may appear that this is very old provision, but the relevance of this judgment is in regard to how to compute the total income of the assessee. Whenever any deduction is to be claimed from the total income, the question arises that how the total income will be computed first. In this present case, there were unabsorbed losses. The assessee was calculating the total income before adjusting these losses, and without claiming these losses in calculating the total income, the assessee was claiming the deduction under section 80 HHC. The impact was that the assessee was claiming more deduction under section 80 HHC. So the assessing officer was having a great apprehension regarding this, and according to him, the set of losses, the unabsorbed losses should be set off from the total income and then deduction under section 80 HHC is to be computed. This was the moot question before the court. The High Court has already decided into the favor of the department, but the assessee was before the Supreme Court. And the Supreme Court said that in this particular case, the losses that is unabsorbed in this particular case are to be adjusted first and then deduction under section 80 HHC is to be claimed. For this, the court referred the section 80A subsection 1, 80B subsection 5 and section 72A. If we read these section in totality, these sections gives the hint that first of all the correct true income should be calculated and then any deduction is to be claimed from that. So what will be the correct income? The correct income will be when it will be calculated according to the provisions of the law. And the provisions of the law says that if any losses are there, first of all it should be adjusted. It should not be like this, that if the assessee is getting the benefit of the more deductions, then the assessee do not have the choice whether to set off the unabsorbed losses or not. So if the unabsorbed losses are there, they should be adjusted first, whether the matter goes into the favor of the assessee or the matter goes into the favor of the department. It is not a matter of calculating high tax or low tax. It is a matter of calculating the true income and true tax. So the court said that the true mannerism of calculating the total income is only after setting of the unabsorbed losses under section 72A, and only then the deduction under section 80 HHC can be given. You cannot skip the methods of calculating the total income. There is a method which has been described both in section 80A subsection 1 and 80B subsection 5. You have to compute the total income strictly in that sense. That is the sense in which the Income Tax Act says that there are 5 heads. Whatever the deductions are there, you claim those deductions. Whatever the losses you have to set off, you have to set off those losses, and then whatever the income is available, then you claim your deduction under section 80 HHC. So in this particular case, now the law is settled that if you have to claim any deduction and if there are unabsorbed losses, then first of all you set off those unabsorbed losses and then claim your deduction under section 80 HHC. So at the end of this video, once again I am repeating the name of the case. The name of the case is Ashok Leyland Limited versus Commissioner of Income Tax. Thank you, friends.